So as a lot of us already know, but if you're new here and you don't know, Amber Heard for the third time is trying to get the Virginia case dismissed. And 10 hours ago of me releasing this video, the real Laura be on Twitter, which I'm going to be thanking again a little bit later on when we get to it, has released the documentation which Johnny Depp's team has set out their opposition for her motion to leave, which is their argument for her trying to get this case dismissed, which is, is amazing to see because their points are on point. And her excuses are just laughable to try and use the UK judgment in this way. This is two totally different cases, and you'd think that her team would know that. I'm sorry guys putting this video on, but it makes me laugh watching her keep flicking her hair back and forward while she is reading her script outside the end of the UK case last year. But as a lot of you know, she put her third motion into attempting to get this dismissed only in April. So like just about 2 months ago, she tried to get this case dismissed again in Virginia. Just after the body cam footage was released, she tried to get it dismissed. And I think it's because she's pretty scared right now, and so is her team, because the lies are unfolding yet again. The lies are unraveling, and her team cannot cope with that. They can't cope with the fact that people are starting to see the truth and that the agenda is falling apart. Here you can see very quickly her motion that she put in, where she tried to use the UK judgment for her reason to be given the motion to leave, saying that that case should be barred. It's just laughable, really. But if you've not seen that already, I will leave the link to that in the description of this video. But we're going to be getting onto that now. We're going to get onto Johnny Depp's team's opposition. It's a bit lengthy, and please do bear with me. You all know by now I have dyslexia, so there's a few words that I do trip up on, but we got through it. So join me back here at the end and we'll just have a bit of a discussion. And by the way, if you're new here, hit that subscribe button and hit the thumbs up as well, guys. Thank you for joining me for this video today. Let's get to it. So thank you to the real Laura B on Twitter for sharing this. She's amazing at getting the information out. Update: Johnny Depp vs Amber Heard. Fairfax. Plaintiff's opposition to defendant's motion for leave to file amend and answer. Grounds of defence and plus supplemental plea in bar. I know this has already been heard and ruled opinion letter not uploaded yet. Okay, so this is Johnny Depp's team's opinion on this. This is their opposition to Amber Heard trying to get a leave on this case. So let's get to it. First, it does the background. Miss Heard's motion asks the court to allow Miss Heard's third baseless attempt to avoid having Mr. Depp's defamation claims against her tried on the merits. First, Miss Heard sought to dismiss Mr. Depp's claims based on forum non-convenience, can't believe pronounce that word, let's carry on, arguing that the case should be heard in California instead. In his letter opinion dated July 25, 2019, the Honourable Chief Judge Bruce D. White denied Miss Heard's motion. Later, after replacing her first set of counsel, Miss Heard saw and was granted leave to file a new demurrer and plea in bar. Again, this honourable court largely denied Miss Heard's demurrer and plea in bar, finding that 4 out of the 5 statements Mr. Depp alleged to be defamatory were actionable, and that his defamation claims were not barred by the applicable statute of limitations. Twice thwarted. Miss Heard yet again replaced her legal team, filing her answer and counterclaims, seeking $100 million in damages for defamation, violation of Virginia's Computer Crimes Act, and declaratory judgment. By a letter of opinion dated January 4, 2021, this court dismissed all of Miss Heard's counterclaims, with the exception of the portion of her defamation claims based on 3 statements made within 1 year statute of limitations. Now, by her motion, Miss Heard, apparently desperate to avoid a reckoning on the merits and the consequences of lying under oath about donating to the Children's Hospital of Los Angeles and the complicit ACLU, seeks one more bite of the apple. This time, Miss Heard seeks to amend her answer on grounds for defence and file a supplemental plea in bar which seeks dismissal of Mr. Depp's claims based on a judgment rendered in a different country. Different laws between different parties, where Miss Heard was not a party and was not a subject to discovery on the court's authority. Specifically, Miss Heard contends that the November 2nd, 2020 judgment, the UK judgment rendered by the High Court of Justice, Queen's Bench Division, the UK court, in Mr. Depp's lawsuit against Newsgroup newspaper and Dan Wooten, entitled Depp vs. Newsgroup Newspaper Limited, somehow bars Mr. Depp's defamation claims against Miss Heard in this action based on the doctrines of comite collateral estoppel, issued the claim preclusion, res judicata, and statutory law. Miss Heard also seeks a stay of discovery pending the outcome of her newly anticipated plea in bar. There is, however, no legal basis to bar Mr. Depp's defamation claims against Miss Heard based on the UK judgment. Miss Heard's proposed amendments to her pleadings and supplemental plea in bar are futile, and this court should accordingly deny Miss Heard's requested leave to, again, waste the court's and Mr. Depp's time and resources litigating frivolous defences which distract from the merits of Mr. Depp's claims against Miss Heard. Argument. This is Depp's team's argument. Okay, so the legal standard. Rule 108 of the Rules of the Supreme Court of Virginia provides that a party must seek leave of court to amend any pleading after it is filed. Though leave to amend shall be liberally granted, a court may, in the exercise of its discretion, deny leave to amend when the proposed amendment is futile as a matter of law. Okay, let's see where we're at. The court should deny defendants leave to file her proposed amended answer and grounds for defence and the related supplemental plea in bar because these new proceedings are futile as a matter of law. In her proposed supplemental plea in bar, Miss Heard fails to even recite the elements necessary to establish res judicata or collateral estoppel, let alone a single Virginia case that actually supports her newest defences based on the UK judgment. In fact, the very authorities Miss Heard cites in her proposed supplemental plea in bar hold that, as a matter of black letter Virginia law, the UK judgment cannot bar Mr. Depp's defamation claims against Miss Heard in this action, nor can it bar litigation of the issues implicated by the same. The application of res judicata is set forth in Rule 106 of the Rules of the Supreme Court of Virginia, which provides in relevant part A party who claims for relief arising from identified conduct, a transaction or an occurrence is decided on the merits by a final judgment shall be forever barred from prosecuting any second or subsequent civil action against the same opposing party or parties on any claim or course of action that arises from that same conduct, transaction or occurrence. Ms. Heard claims that the Supreme Court of Virginia has held that in its abuse of discretion for a court to deny leave to file an amended pleading when there is no prejudice to the opposing party. The Supreme Court held no such thing in the case cited by Ms. Heard for this proposition. The Supreme Court explicitly recognised that a court may decline to grant leave to amend when, for example, the proffered amendments are legally futile, but found that the proposed amendment stated a viable claim, i.e. was not futile and was not prejudicial, noting that the court need not reach the issue of whether plaintiff would be prejudiced by a post-trial amendment and denying leave to amend because the amendment would be futile. Under Virginia law, a party invoking the doctrine of collateral estoppel also bears the burden of showing inter alia that the parties to the two proceedings are the same or privity. Here, however, it is undisputed that the parties to the UK action and the action pending before this court are not identical, and Ms. Heard does not even contend, let alone show, that she is somehow in privity with the UK defendants. Ms. Heard's res judicata and collateral estoppel defences are thus dead on arrival. Ms. Heard's claim that the UK judgment bars Mr. Depp's defamation claims in this action based on principles of committee fair no better. She fails to cite any authority in her proposed supplemental plea bar holding that principles of committee endow the UK judgment with preclusive effect here. In the two cases, Ms. Heard cites the court's decline to grant a foreign judgment preclusive effect, finding that a foreign judgment was not a bar to suit inequity between the parties in the US. We are not confronted with a committee analysis which would require us to determine whether a Swiss judgment has not been rendered under. So this is just referencing where this came in. Ms. Heard's res judicata defences also fails as a matter of law because the UK action does not arise from the same occurrence, conduct or transaction as this action. The Fourth Circuit has already held that the two separate instances of defamation, even if regarding the same subject matter, i.e. Ms. Heard's op-ed and the article that was subject to UK action, do not arise from the same transaction or occurrence. The Supreme Court articulated the precise reason why the UK judgment should not be afforded committee and preclusive effect with respect to Mr. Depp's claims. Committee is not extended to judgments like the UK judgment that are founded on the unique laws of a foreign jurisdiction. Furthermore, US courts have declined to apply the doctrine of committee in the manner Ms. Heard requests in her supplemental plea in bar, asking a US court to adopt and recognise the preclusive effects of the factual findings of a foreign court, when, as here, the parties to the US and the foreign proceedings are not the same or in privity with one another. Generally applies to both parties involved in the foreign dispute. There is no legal basis under principles of the committee, res judicata or collateral estoppel to afford the UK judgment preclusive effect with respect to Mr. Depp's defamation claims against Ms. Heard. Ms. Heard proposed amendments and supplemental plea in bar are futile and thus provide no basis to stay discovery that has been ongoing for over 2 years. The court did not stay discovery when Ms. Heard filed her private two sets or failed dispositive motions or during the pendency of Mr. Depp's motion to dismiss Miss Heard's counterclaims, and it should not do so now at this late stage into litigation. So there we have it, guys. That was put out there by Johnny Depp's team. That is their opposition to her motion, to Amber Heard's motion, which I love their points. Yes, it is absolutely laughable that Amber Heard is trying to use the UK judgment to get this case dismissed. Well, get a motion to leave or whatever you want to call it. She's trying to use the judgment from the UK, but she was only a witness. She wasn't a party. No, was she heck? These are two totally different cases. In the UK, it was Depp versus NGN and Dan Wooten. This is between Depp and Heard, or Johnny Depp versus Amber Heard. Two totally different cases going on. And the fact that she thinks that this will help her succeed, it just makes you laugh, doesn't it? But I know that this judge in VA is very strict, and she's already said that if she finds that Amber Heard is wasting her time, then she's gonna be sanctioning her very hard. Because that's all she's doing. She's wasting the time of the courts, of Johnny Depp, of Johnny Depp's lawyers. She's wasting everybody's time. And you know what it is? It's because she is terrified right now. Anyway, guys, I just want to tell you all thank you all for watching. And, you know, thank you for subscribing to my channel. If you're not subscribed already, please think about hitting that subscribe button. If you can, share this video out. Leave me your thoughts in the comments down below as well. I love you all so much. I hope you have an amazing day, morning, afternoon, evening, night, wherever you are. And I'm just going to let this little Johnny Depp video play out because, you know, we started it having to watch her. I'd much prefer finishing it watching this here. So again, thank you all for watching, guys. I love and appreciate you all so much.
$7 million in total was donated to, I split it between the ACLU and Children's Hospital of Los Angeles.
You see, that's something that I've never heard
I wanted
of.
nothing.